Hi, everyone. Thanks so much for joining. We'll get started in just a minute. All right, let's go ahead and get started. Thank you, everyone, for joining. Today, we have Michelle Roberts, and she'll be presenting ERISA disability benefit claims for the non or new ERISA attorney. First, I'll begin with a quick overview of my organization, then I'll introduce today's presenter, and we'll move into today's training, and we can handle questions as they come up throughout the presentation. This training is being recorded and everyone is muted. You can enter your questions into the Q&A function and we'll go ahead and read them out loud and answer them throughout the presentation. And then you must complete the evaluation in order to receive MCLE credit. That evaluation will automatically open up in your browser window after the webinar ends, but I'll also send that link out by email. We post our virtual CLE presentations on our CLE Heroes site where you can view them for credit. That URL is on the screen now. And now just to spend a little bit of time introducing ALRP. We were founded in 1983 in response to the AIDS epidemic. And at that time, we were just 4 attorneys drafting wills and durable powers of attorney for those who were dying of AIDS. Drafting legal documents like these allowed individuals to fulfill their wishes about healthcare and disposition of assets. As the needs of our clients have evolved, so too has ALRP, and we've handled over 80,000 different legal matters since 1983. The stresses of legal issues can make it difficult for our clients to manage their health, especially when these issues are threatening their access to shelter or employment or medical care. 80% of our clients are living on incomes of $30,000 or less, so they really rely on our free and low-cost legal services. We offer direct services in-house with our staff of attorneys, in addition to operating as a lawyer referral panel, maintaining a very large and diverse community of volunteer attorneys. Between our staff and our panel, we are able to help our clients with a wide range of legal matters, including housing, immigration, and employment. We really have 2 goals in offering these trainings. First, we hope to increase the capacity of attorneys serving those living with HIV or AIDS. And second, we do hope to recruit new talent to our panel to help us meet the legal needs of those living with HIV or AIDS in the San Francisco Bay Area. If you aren't currently on our panel, we really hope you will consider joining. As an attorney on our panel, you play a key role in helping us provide these low-cost legal counseling and representation services to our clients. We just ask that you accept 2 referrals a year, and you always have the option to pass on a referral if you aren't able to handle a new client at that moment. We tailor the referrals to your experience and your availability, and we conduct a thorough intake with each client so that we can make a good referral. Just to name a few benefits of joining the panel, you have access to these free MCLE trainings. You have the opportunity to either be mentored by another panel attorney or mentor another panel attorney. You are covered under our malpractice insurance, and there are networking opportunities. If you're interested in joining the panel, please don't hesitate to reach out to me directly by phone or by email. And now to introduce today's presenter. Michelle Roberts is the founder and principal of Roberts Disability Law PC. Since 2005, Michelle has represented individuals in claims for benefits under the Employment Retirement Income Security Act of 1974, ERISA, specifically claims for disability and life insurance benefits. She counsels clients in all stages of an ERISA claim, including at the initiation of the claim, the appeal of a denied claim, and in litigation, federal district court, and the courts of appeals. Michelle serves on the board of senior editors of the ABA Employee Benefits Law Book and is co-author of the ABA's ERISA survey of the federal circuits. She is also the tort, trial, and insurance practice vice chair to the Employee Benefits General Committee. Michelle is the author of a blog called ERISA Circuit Review, where she publishes summaries of recent ERISA decisions from all the courts of appeals. Each year from 2015, Michelle was named a super lawyer by Northern California Super Lawyers magazine, and in each year from 2018, she was named on the Northern California Super Lawyers Top 100 and Top 50 Women's Lawyers list. Michelle received her JD from the University of California, Berkeley School of Law, and her full bio can be found online at robertsdisability.com. And with that, I will turn things over to today's presenter. Michelle, thank you so much for being here.
Hi, thank you for having me. And I'll go ahead and share my screen. And while I'm doing that, I really do want to put in another plug for joining ALRP as a panel attorney. I've been a panel attorney for many years now, and I was co-chair of the board for a few years, several years ago. And ALRP is just a really important organization, and they do great work. So I will now start off on talking about ERISA disability benefit claims. And this presentation is really geared for people who are attorneys who may have dabbled in ERISA or considering adding it to their practice, or just want to be familiar with this area because it comes up a lot for their own clients and they want to be able to help issue spot. So the topics that I'm going to cover today, I'm going to do a brief introduction into ERISA, how to identify an ERISA plan, what are the available claims and remedies under ERISA, and focus really on the disability insurance aspect. So what are common terms in long-term disability policies? What should you be watching out for, especially as you're considering taking on a potential client who has a denied ERISA claim? We'll talk about the ERISA benefit claims procedures, tips for preparing a strong pre-litigation appeal, which is normally necessary before you can even file a lawsuit, and how to avoid inadvertent waiver of ERISA claims, particularly in severance agreements. So with that, what is ERISA? ERISA is actually more than just my license plate. Yes, that is me, and that is my car. I have to be very careful about not cutting people off in traffic because they can find me probably pretty easily with that. So ERISA is a federal law that was enacted in 1974 in response to widespread pension problems. But then it was enacted to cover not just pension benefits, but health and welfare benefit plans as well. And it basically provides minimum standards for voluntarily established benefit plans in the private industry. And I stress voluntarily because ERISA doesn't require that any employer provide any particular benefit, but if they do, they have to provide those benefits according to some very minimum standards. And it's important to note that ERISA preempts any state laws as it might relate to an employee benefit plan. So if there is a denied claim, you can't sue under state law. You do have to bring the claim under ERISA. So ERISA governs employee benefit plans, and that includes pension benefit plans and welfare benefit plans. And under welfare benefit plans, you have short and long-term disability plans, which we're going to talk about a lot today, health plans, a lot of severance plans are actually considered ERISA plans, and life insurance and accidental death and dismemberment plans. Those are the common types of plans that we see. Claims that are not governed by ERISA, but not every single benefit plan is going to be covered by ERISA. Government plans, so if you're a government employee, benefits that you receive through work are not going to be covered by ERISA. Church plans, plans that are maintained solely to comply with certain laws like workers' compensation or unemployment insurance, that's not going to be considered ERISA. If somebody has an individual insurance policy that wasn't obtained through an employer, that's likely also not going to be covered by ERISA. And then there's a payroll practice exemption, which looks like kind of like a short-term disability plan where an employer may pay an employee's normal compensation while that employee is out due to physical or mental conditions or otherwise absent for medical reasons, and they continue to pay their salary, and it comes out of the employer's general assets. It might look like an ERISA plan, but it's going to be considered exempted as a payroll practice. So you have to be careful, because sometimes an employer will have a payroll practice for like a short-term disability benefit, but then they might have an ERISA governed long-term disability plan. There are formal and informal plans, and I think most of the plans that we're going to see in the disability context are going to be formal plans, meaning that they have a written plan document and they comply with the ERISA. But where it's not clear, where there's a benefit that's being offered, but it's not being represented as a formal ERISA plan and there's no plan document, there is a test that you apply to ascertain whether or not ERISA would apply, and that's whether they are intended benefits, the intended beneficiaries, the source of financing, and that there's a procedure for obtaining benefits or an ongoing administrative program. And this comes up a lot with severance plans, because sometimes severance plans purport to be ERISA plans or they don't, but they might be. And so you see a lot of litigation around severance plans and whether or not they're covered by ERISA. And here, Danica, if we could put up the first poll.
Happy to, let's do that. All right, here's our first poll question. All disability benefits provided by an employer are governed by ERISA, true or false? Give everyone just a little bit of time to answer. All right, and we have 92, 93, 94% of our respondents saying false.
That is correct. Yes, most of you were paying attention. Not all benefits provided by an employer governed by ERISA, because remember, you could be a government or a church plan, and that's not going to be covered by ERISA. All right, so I don't know how to let's see, take this off my screen. Okay, so let's talk about the types of ERISA claims. And I'm not going to talk about every single ERISA claim because we only have an hour and you probably haven't had enough coffee. But we're going to talk about several of the most popular ones. ERISA Section 502A1B is the civil enforcement provision under which you bring a claim when you have a denied benefit. And so it can be brought by a participant or a beneficiary of an ERISA plan to recover benefits that are due to him under the terms of the plan, enforce rights under the terms of the plan, or to clarify rights to future benefits under the plan. And this is the most common ERISA claim that is brought, particularly with respect to a denied claim for disability benefits. There is also you can bring breach of fiduciary duty claims under ERISA. So ERISA Section 502A2 is the provision under which you can bring a breach of fiduciary duty claim on behalf of a plan. So this is often brought in the pension context, where a plan participant might say, somebody who had responsibility for managing plan assets breached their fiduciary duty, and you want to seek restoration on behalf of the plan as a whole. There's also ERISA Section 502A3, and I bolded this one because this is, I think, next to the A1B claim, the second most popular claim, and that is a breach of fiduciary duty for other appropriate equitable relief that an individual can bring on behalf of themselves. ERISA Section 510 is for interference or retaliation. So an employer is not permitted to take adverse employment action against you in order to interfere with your right to participate in the plan or to receive a benefit. So this is commonly brought in situations where someone might be terminated right before their pension's about to vest because the employer doesn't want to pay those pension benefits. So that's typically where you see that type of a claim. There are also civil penalties under ERISA where that are available if an administrator, which is normally the employer, fails to supply information requested under ERISA. So if you, for instance, have a client who requested plan documents from their employer because they wanted to understand the terms of their plan and the employer didn't provide those plan documents, there are penalties that accrue after 30 days. at the rate of $110 a day. So it's pretty significant. Courts have a lot of discretion as to whether they will award those penalties, and they're often cut back. But it's good to make sure that clients are requesting plan documents in writing to the proper entity, so that if they are late in responding, there is this threat of potential penalties. Okay, so what are the ERISA remedies? And the remedies issue in ERISA is just, it's, again, you can have a whole CLE just on remedies. And it's one of the reasons why you don't have as many people or as many attorneys practicing in this area of law, because remedies are pretty strictly limited. So you can get payment of plan benefits. So for example, if someone is denied a disability benefit claim, they can file suit and seek payment, retroactive payment, and payment into the present, and then reinstatement into the plan. Attorneys' fees are available, which is the one really great thing about ERISA, and enables attorneys to take on cases that may not be worth that much financially, especially with all the time that goes into preparing an appeal. But if you file suit and you win, there is a fee shifting provision. Now, you need not be a prevailing party, even though I said attorney's fees for prevailing party. You just have to be a successful party. So you have to show some degree of success on the merits, and then you can get fees paid, but only for time that is spent related to the litigation. So if you take on a client and you help them at the appeal stage, and then that's not successful, and then you file a lawsuit, your fees or the time that you spent preparing the appeal won't be compensable, but at least all the time that you spend related to the litigation would be. But it is a two-way fee statute. So that means a prevailing defendant or a successful defendant could potentially get fees against a losing plaintiff. But the way that this provision is applied, particularly in this circuit, in the Ninth Circuit, most courts will not award fees against a losing plaintiff unless you can show that the claim was like clearly frivolous or made in bad faith. Other forms of monetary damage, such as consequential damages, punitive damages, emotional distress, those are not available. And so in a situation where you might have a claim where an insurance company denied disability benefits, and let's say your client lost their home or had to file for bankruptcy, there's no compensation for that. And that's really one of the biggest limitations in this area of law. And another one is there's no jury trials. And that can be a good or a bad thing, but the case when it goes to the court is going to be decided by the judge on a record that's typically created before you file a lawsuit. I want to talk a little bit more about what is equitable relief. There was a big Supreme Court decision in this area of the law called Signacor versus Amara that was decided in 2011. And it's really changed the landscape of potential available remedies under ERISA Section 502A3. And the Supreme Court in the Amara case approved of monetary relief in the form of what we call an equitable surcharge. So even though I said you can't really get money damages under ERISA, if you can get a surcharge in the form of equitable relief if certain conditions are met. And that's been, really interesting development in this area of the law, in particular around denied life insurance claims, because in the past, let's say like an employer screwed up enrollment or did something where somebody couldn't file an A1B claim for insurance benefits because they weren't properly participants in the plan, or the plan just didn't provide them insurance. Now there are more avenues for relief against an employer in that situation by filing a 502A3 claim and asking to be made whole and seeking an equitable surcharge. And on that note, we have another poll.
Right, thank you. Here we go. All right. Which of these remedies are not available under ERISA? Equitable relief, attorney's fees, emotional distress, payment of retroactive benefits. Give everyone just a minute to share their answers. All right. Okay, most of our respondents, 80%, chose emotional distress, with a few choosing equitable relief and attorney's fees.
Yes, and the correct answer is emotional distress. That is not available under ERISA. Okay. So moving on. Now let's talk about long-term disability claims. It's important to note that and I'm going to use the term LTD for shorthand, it stands for long-term disability, but every LTD plan is different. And there are insured and self-funded plans. And it's important because every LTD plan is different, that you have to obtain the plan documents from the plan administrator, which is the employer. This is not like, state disability insurance benefits or Social Security benefits where across the board exactly what are the eligibility requirements, the waiting periods, all of that. So in order to determine that for every client, they have to get the LTD plan documents from the plan administrator. To do that, it's simple. You just make a written request under ERISA section 104(b)(4) and send that to the proper entity. The proper entity can often be determined by looking up the Form 5500 online, which you can do for free on the Department of Labor website. And many plans will file this document called a Form 5500, which will name the plan administrator. So if you're not sure, you can go online and look and see if you can determine who the plan administrator is and then send that request in writing, preferably with some kind of tracking. And a lot of times clients, especially if they're still employed, can ask HR or access some internal database that has all of the plan documents. And it's important to get that. And the plan documents that we see in the LTD context, if it's an insured plan, is going to include a certificate of insurance. There may also be a global wrap document that's prepared by the employer, or a summary plan description, which will talk more about the terms and the eligibility requirements. But if it's an insured plan, you definitely also want to get the underlying insurance policy. So what I'm going to do is, in identifying sort of what are some key terms you want to be aware of, we're going to look at Google's disability certificate. And Google knows everything about us, so now we're going to know a little bit about their program. So the Google disability policy is insured by MetLife. And okay, so the first thing that you want to look at, is your client eligible for benefits? Pretty much all policies are going to describe what is an eligible class. Typically, you have to be a full-time employee, or you have to work a certain number of hours, 20, 25, 30, it varies. In this case, for Google, you have to work 20 hours or more per week for at least 5 months during a calendar year. And this particular policy excludes certain categories of employees, so variable, part-time employees, interns, leased employees. So it's important to know that, because sometimes someone might think that they're covered because they're working part-time, but they're not working quite enough hours. So you want to make sure that the claimant is actually eligible for the benefits. The policies are also going to specify the benefit amount and the waiting period. And again, this varies from plan to plan, but in this case, Google offers 60% of the first $25,000 of pre-disability earnings. Here, there's a maximum monthly benefit, so there's a cap. And it's important to look at the cap, because sometimes you might have somebody who comes in and let's say they're making $200,000 a year, and they represent that, oh, I have 60% coverage of my benefit, but then you look at the policy and they might have a maximum monthly benefit of $5,000. So you really want to look at what's the maximum and what's the minimum. The minimum is important because, as we're going to talk about a little bit later, there are a lot of offsets to these policies. And so sometimes somebody might have what could be a significant benefit, but because of other income sources, they end up receiving a really small amount or just the minimum monthly benefit. And then the elimination period is basically a waiting period. How long do you need to be disabled in order to qualify for benefits. And so in this case, it's the greater of the short-term disability maximum benefit or 180 days. So sometimes employers will provide a short-term disability benefit, and it's supposed to, LTD kicks in when the STD ends. But I've seen LTD plans that have really short elimination periods, like 60 days, and ones that have really long periods, like a year. I haven't really seen any that are longer than a year. On average, the waiting period is about 180 days or 6 months. Okay. You also want to know what is the definition of either pre-disability earnings or covered earnings. And this is important because a lot of these policies will only pay or cover or insure base salary and not anything extra like bonuses or commissions or anything that might constitute a significant portion of a client's income. And so you want to know, what is actually being covered here. And in this case, it was interesting that Google, they must have a lot of massage therapists on site because they have, their own pre-disability earnings definition that's just for massage therapists. Okay, so a lot of times, like I think I mentioned this just a moment ago, pre-disability earnings or covered earnings won't include certain extra compensation like bonuses, overtime pay, contributions that are made on a client's behalf to a deferred compensation arrangement or a pension plan, or any extra compensation from the policyholder. So it's important to know exactly what's being covered because it can make a huge difference in terms of the value of the benefit. So another thing that you want to be mindful about are the maximum benefit periods. So most policies will pay to Social Security normal retirement age. And so if you were born after, I think it's 1960, your retirement age is going to be age 67. Some will pay only to age 65. And I've also seen some with even shorter caps. I believe the smallest length of time I've seen insured is about 5 years. So you want to double check that and don't assume it's going to be to normal retirement age, even though a lot of policies will pay to normal retirement age. Right. The definition of disability. Now, this is really important. And there's a wide variety of definitions among these plans. Most will have what we call an own occupation and an any occupation definition of disability. So typically for the own occupation definition of disability, this will apply to the first 24 months of disability. Some plans might only have it for 12 months. Some plans might have it for the life of the claim. It might be an own occupation claim forever, well, not forever until retirement age, but those are really great plans, but most will say, we will pay you for 2 years if you can't perform with reasonable continuity the substantial material acts necessary for your own occupation. But then after that time, in order to continue qualifying for benefits, you have to be unable to engage with reasonable continuity in any occupation, but not just any occupation, one that you can perform satisfactorily given your age, education, training, experience, station in life, and physical and mental capacity. And I want to talk a little bit about this station in life requirement, which is in this Google policy, and it's in a lot of policies, but where it's missing, it's really difficult. So station in life means essentially that you need to be able to make 60% or more, 60 to 80% of what you were making previously. And so if somebody was making $500,000 a year and they were disabled, but they could work at a job that would pay them $50,000 a year, that's not going to make them disqualified from long-term disability benefits, because they have to be able to find an occupation which could reasonably provide income that would help them maintain their station in life. Where a policy does not have like a gainful earnings requirement like station in life, or say that you have to be able to make at least 60% of what you were making before, then the insurance company has a much stronger argument to say that one's ability to transfer into some other type of occupation, even if it might not provide station in life earnings, is enough to deny benefits. Many policies have partial disability benefits, and that means that you can't work in your own occupation, but you are working, you're doing some work, and you are earning usually at least 20% of your pre-disability earnings, but less than 80% of what you were making before. And so you can continue working, earn partial wages from your employment, and then also get a partial disability benefit from the insurance policy. It is important to make sure that the plan has this definition of, or they provide benefits for partial disability, because not all policies do. Some policies provide that if you're performing any work, you're just not going to be eligible for benefits. One thing to also keep in mind is that most of these policies do not have cost of living adjustments for the gross benefit. So let's say, somebody's gross benefit is $5,000 a month. That $5,000 a month is going to stay pretty static until that person reaches the end of the maximum benefit period. So if somebody becomes disabled at age 40 and they stay on claim until age 65, they're only entitled to that $5,000. But what we'll see sometimes in these policies, and so you don't want to confuse it for a cost of living benefit, but what they'll do is, for purposes of determining partial disability, they will adjust your pre-disability earnings to account for cost of living. Because let's say somebody is not totally disabled, they're partially disabled and they're working, but due to inflation, due to raises and cost of living adjustments in their wages, their income increases slowly over time. But if you don't account for their pre-disability earnings also increasing as a result of cost of living adjustment, they're going to exceed that 80% mark pretty quickly. And so for purposes of determining partial disability, they'll say, okay, we're not going to increase your gross benefit amount, but we'll take your pre-disability earnings, we'll apply a cost of living increase so that you can continue working part-time and still get at least some benefit under the policy. Another important provision, you want to look at the termination of coverage provisions. So what will cause coverage to end? This is a list of some pretty typical standard terms. The group policy just ends altogether. Your insurance ends, the employer stops paying or you stop paying the premiums for the coverage, or you cease being in an eligible class and you're not active at work. And this active at work requirement is one that gets a fair amount of litigation, because sometimes somebody is not active at work because they are disabled, but let's say their employer continues paying them their full salary. And so when they do eventually file a claim, the insurance company can say, well, you weren't actively at work, so you didn't have coverage. So you want to be careful and understand the import of the active work definition. A lot of times coverage will end as of your last day of work. This policy has it that it ends the last day of the calendar month in which your employment ends. So if someone is fired on April 2nd, they will have coverage through April 30th, 31, how many days are in April? But you don't want to assume that coverage will always extend to the end of the month. It's often the last day of work, but again, you have to look at the policy and figure it out before you can really counsel a claimant on what to do in terms of their coverage. The question I get the most from potential clients and clients who are about to leave work or maybe about to be terminated due to poor performance because of their disability is that they're worried that they have to file a claim right away before they're terminated because they won't have coverage. And so it's important to note that what matters is that you were disabled as of the date that you had coverage. So you don't have to have filed a claim necessarily as of the date that you become disabled. But let's just say hypothetically, somebody was performing poorly at work because of disability. So arguably they were disabled, not able to perform the substantial duties of their employment, and their employer fires them. They can then arguably file a claim and say that they were disabled as of their last day of work while they had coverage, because they weren't able to perform the material and substantial duties of the job. And they would just file that claim using the date that they were terminated. And that is perfectly valid claim, but I always get a lot of very stressed out phone calls from potential clients who are really worried that they can't do anything now. They had to file the claim while they were employed, and that's typically not the case. So termination of coverage is much different than termination of benefits. So coverage just goes to, as long as you had a claim for disability that arose while you had coverage, if coverage terminates later after that, it doesn't affect you because you already have a claim. But once you have a claim, you want to know what are the conditions under which these benefits could be terminated. So again, here's a list of examples from the Google policy. The end of the maximum benefit period. So if you have a claim that pays to age 65 and you're 63 at the time you become disabled, it's going to stop at the date that you turn age 65. A lot of policies also have limited pay periods for certain conditions. The most common are mental health related type disabilities. So if you are disabled by something like depression or anxiety, a lot of policies will only pay for 24 months. And so if you have a disability that is only based on mental illness, you don't have like a separate quote unquote physical based disability that could potentially extend the benefits out further, you're only going to receive usually about 2 years benefits. That's not the case with every policy. I've seen some policies that just have no mental health limitation, and those are great, but those are pretty few and far between. Those are also not illegal. I get a lot of questions from attorneys and potential clients about, are they allowed to, with mental health parity, limit what they pay for a mental health disability? And the short answer is yes, they can. Mental health parity does not apply to these private disability insurance plans. And so they can limit claims, not just for mental health disabilities, but for really any type of disability that they want to. We often see limitations for conditions such as chronic fatigue syndrome, fibromyalgia, other conditions which tend to be harder to support medically, conditions or disabilities based on self-reported symptoms that don't really have objective evidence. Those are typically limited. The date, so other things that would cause your benefit to terminate is that the insurance company says, we don't think that you're disabled any longer. The medical evidence doesn't support your claim. Obviously, if you die, you don't get benefits. Sometimes some policies will provide a survivor benefit to your beneficiaries of about 3 months of benefits, but it's not something that continues to pay to your estate or anything like that after you die. And a lot of policies will give themselves, or the insurance companies will give themselves the right to have you examined in person by a doctor of their choice. And if you fail to reasonably cooperate with a request to be examined, that can also be a basis for a termination of benefits. And it is always the claimant's responsibility to provide proof of continuing disability. So getting a claim approved at the outset is usually not the end of the story. The insurance company, depending on the nature of the disability, may ask for updates as frequently as every month, every 3 months, every 6 months, every year. It really depends, but it is the claimant's responsibility to provide that proof of continuing disability. And absent, and if that's not provided, an insurance company or plan administrator will terminate benefits.
Just a quick time check. About 35 minutes has elapsed and we don't have any questions.
Okay, great. Thank you. So let's talk about temporary recoveries, because this question comes up a lot as well. Some people do return to active work after they have completed an elimination period. So let me give you an example. Someone goes out on leave, they're disabled for the full 180 days of the elimination period. They start getting a benefit. Then they start to feel better. And they're like, let me take a stab at going back to work. And typically they go back to work for the policyholder. So they go to work and they're kind of testing it out. A lot of policies will say, if you go back to work for a period of 180 days or about 6 months, and you become disabled again due to the same or related sickness or injury, we're not going to make you wait and satisfy a new elimination period. You can go back out and just reopen your claim. But if you go back to work for more than 180 days or 6 months, and then you go out on disability again, you will have to satisfy a new elimination period. And this is important because let's say somebody returned to work and they returned to work in kind of a different occupation because maybe it was accommodated, and they returned to work at a lower salary. If they work in that position for more than 6 months and then they go out on disability again, arguably the insurance company, would have an argument that the salary upon which they would base the benefits is the new lower salary rather than the previous higher salary. So it's something to be mindful of, and to be able to, you can counsel your clients correctly if they are considering returning to work either for the policyholder or for a different employer. Work incentives. Most policies have work incentives because they want people to go back to work. They don't want to pay the claims. And so it's important to note how work incentives are going to be applied to your client. Often, especially in the first 2 years of disability, the work incentive benefit's a little bit more generous. They won't reduce what your client will receive in monthly disability benefits if somebody is working, unless they exceed 100% of their pre-disability earnings between both the benefit and the disability earnings. And then after some period of time, typically 24 months, but again, every policy is different, so you have to look at your client's particular policy, they'll offset or reduce the monthly benefit payable by 50% of the amount that is made while working. So it's not a complete one-to-one offset. So not every $1 you make means you're going to lose $1 in benefits, but there is a reduction if one does go back to work. Okay. So I've been talking a lot about offsets. And offsets are reductions. They're reductions to the benefit. And sometimes these offsets can be pretty significant, especially if your client also has something like a workers' compensation claim or a third-party settlement because maybe they were injured from a personal injury suit and then they got a settlement. So here are the offsets that are in the Google plan. And these are also pretty standard and typical, and we see them a lot in most other policies. Any benefits that the claimant, their spouse, or their children, and that's important because people think, that their children, yes, they will offset benefits that the children receives under something like the Social Security Act if the child received the benefit as a result of the parent's disability. So they want to look at pretty much all your household income. So if your benefit is $5,000 a month, and let's say you get $3,000 from Social Security and the child gets $1,500 because the child usually gets about half of what the parent receives, that's a pretty significant offset. You're only going to get pretty much $500 from the LTD plan after they reduce the benefit by what the claimant receives in Social Security. Temporary disability benefits under workers' compensation. I've also seen policies that have, they offset not just temporary disability benefits, but permanent disability benefits as well. And federal, we talked about that. So retirement benefits, not just Social Security benefits, third-party liability payments, sick pay, return to work earnings, a lot of this. So I would say, if your client is considering, or what I tell all my clients, before you take out any retirement benefit or apply for retirement benefits or do anything regarding other income, check in with us first, because we'll be able to advise you as to whether or not this is going to affect your long-term disability plan.
All right, and we have a few questions that have come through.
Okay.
We have 4. So first question, what if the employee returns briefly to active work, but to a new employer. Does the plan follow them to the new employer?
Possibly, yes. And so it depends on the how much that person makes at the new employer. A lot of policies will say that, we find that you could still be disabled, and as long as you're not making 80% or more of your pre-disability earnings. And so then what they'll do is they'll apply the return to work incentives and then adjust your benefit accordingly. But if you make over a certain threshold, or if you become covered under the new insurance or new employer's insurance plan, that may be a basis for a termination of benefits. But I have seen a lot of clients do go back to work, but for a different employer, because they get some kind of accommodated work, or they do something that's not quite their own occupation.
Great. Next question. Is an employee entitled to any privacy of medical facts other than those used to establish disability?
So one thing to keep in mind is that when a client files a claim for long-term disability benefits, it's a lot different than when they are seeking a reasonable accommodation with an employer, where there's a lot more protections. So, when you ask for an accommodation from your employer, especially in California, you're not required to give a diagnosis. And there's big limitations on what an employer can find out. It's much different in the context of the ERISA plan and the plan administrator or the claims administrator, which is often not the employer. It's either the insurance company or a TPA that's not supposed to share that information with the employer. So they will usually ask for all of the medical records, anything that's going to be related. But if something is completely unrelated, like for example, we have clients who have let's say physical-based disabilities, we're seeing an oncologist or a neurologist, whatever, we'll say, okay, you can have those notes, but we're not going to give you the mental health treatment notes because we're not claiming a mental health disability. And we can generally, we don't get a lot of pushback if there's no mental illness aspect to the claim. So in that way, I would say, there's good arguments for, you not being, or them not being entitled to that. But you really can't cherry pick from a set of records and say, okay, well, here, I'm going to give you 5 out of these 10 treatment notes because I don't really like what is said in the other treatment notes. So there's some, you can keep some information private, but when you put your health and your disability up for, say, question, but like when they have to do an investigation, and so they're entitled to determine what's causing the disability, because if the disability is something that they're going to claim is mental, they might push really hard for those notes, and you might have to give them. So I'm definitely, I can answer if there's something more specific about that particular question, maybe offline or after this, but that's in general, most of what a claimant will have to disclose much about their medical condition and their records for these claims.
All right, thank you. Third question. How does an employee establish that the employee had a disability before being terminated? Is a doctor's note of that employee enough? Does the employer have to have notice of this disability in any way before the firing?
It is not important that the employer have notice. What's important is that the medical records will establish that the person had a medical condition and impairments which would impact their ability to do their job. So it's not something that has to be disclosed to the employer. Is a doctor's note alone typically enough? No. But if there is, you have 6 months of medical records which show that you have a condition which has been progressively deteriorating and causing problems at work, that's usually what we rely on. And often we also will submit statements, get statements from the claimant, their friends, family, anybody who might have observations of that person's struggle, and also just to create like a whole picture of, why or how somebody was disabled as of their last day of work. And that's what caused them to stop working ultimately.
Okay, great. And just one more. If there is an ERISA severance plan, is there any way to negotiate for better benefits for one individual employee?
You can always negotiate outside of the ERISA plan. An ERISA plan is going to probably have its own formula for how benefits will be calculated. And so as an ERISA plan administrator, they have the duty to administer the terms of the plan fairly and evenly across plan participants. So they can't offer you typically additional benefits under the ERISA plan, but I don't see any reason why an employer outside of an ERISA plan couldn't have a separate deal with you, especially if you have certain claims or whatnot. I don't see anything that would prevent that from happening, but not increase severance benefits if it violates the formula or is contrary to the formula that's in the plan.
Great. And that does it for the questions. Thank you.
All right, great, and great questions. So let me talk a little bit more about limitations and exclusions. One that we see in long-term disability policies are disabilities as a result of substance abuse. Google has what I think is probably a fairly generous policy with respect to these disabilities compared to other policies which limit claims to about 2 years. They'll pay for 60 months of benefits if somebody is disabled due to substance abuse or addiction. They do require that you participate, or claimant participates, in alcohol, drug, or substance abuse or addiction recovery program. I talked earlier about the mental or nervous disorder limitation. Google, again, will pay for 5 years, more generous than most. A lot of these mental health exclusions do not apply to conditions such as schizophrenia, dementia, or anything based on an organic brain disease. It's really important, though, because every policy is different on how they define mental or nervous disorders. There was a Cigna policy, or Cigna, which is now New York Life, where they interpreted a certain provision that they had in some of their policies as not applying to disabilities stemming from bipolar disorder. And that was good because some other policies did explicitly include bipolar disorder as one that they would only pay for 24 months. So it's important to really understand what is the definition of mental or nervous disorder in the policy. Other typical limitations and exclusions: disability income will not be paid typically for disabilities caused by war, your participation in a riot, or commission of a felony or attempt to commit a felony. Let's talk now about ERISA benefit claims procedures. And this is really important. ERISA is a pretty highly regulated area of the law, and all of these regulations govern the claims procedure before you can file a lawsuit. So when there is a claim for benefits, a claims administrator has to make a decision within 45 days of receipt of the claim, but they can take up to 2 30-day extensions. That gives them a total of 105 days. And sometimes they even extend that out longer if they argue that there's information that they absolutely need to make a decision, but the claimant hasn't submitted it. So they'll say they get to toll their deadline. But I try to tell claimants that this is not something that, if you file a claim, you're going to typically see approved in a week. Sometimes it can take the full 45 days or the full 105 days. But if there's a denial, the administrator has to issue a written decision, providing, in the context of a disability benefit claim, 180 days to perfect that claim and submit an appeal. And 180 days might seem like a long time, but sometimes these disability appeals can be very time intensive to put together. And so you want to start as early as possible in that process. It's always really frustrating sometimes when a potential client comes to you on day 179 and they're like, I think I've got this deadline, and you're like scrambling to try to get an extension, because it's really important to get that appeal done right. And so once you submit an appeal, the administrator has to make a decision within 45 days for a disability benefit claim. It's longer if it's a non-disability claim. And they can take up to one 45-day extension if there are special circumstances. And we see this abused all the time. Insurance companies just assume they're always going to automatically be entitled to that extra extension. But they do have to show and articulate special circumstances. One of the things to keep in mind with respect to the 180-day deadline right now is that they are currently extended because the Employee Benefit Security Administration issued a disaster relief notice after COVID, which provides that for claims for benefits that are denied after March 1st, 2020, they're going to get more than 180 days to appeal. They basically get an extra year on top of the 180 days. But once the national emergency ends, which is currently set to end May 11th, they're basically going to only get an extra 60 days on top of the 180 days that they would have to appeal. So for example, a claim that is denied on January 1st of this year, the appeal would be due January 6th of next year. So you take 60 days from May 11th, the date that the national emergency ends, and then you add the 180 days that they have to appeal. Just because you have that time doesn't mean you should take it. Evidence gets stale. So you want to make sure that you appeal as timely as possible. But if you have somebody who came to you after the 180-day appeal deadline, not all hope is lost. Okay, so the 180-day appeal deadline is a minimum, and this is what I like to remind insurance companies when they refuse to give extensions. But if you need an extension, get it in writing, confirm that they will give you extra time to submit the appeal. You have to submit the appeal on time. If you are late by 1 day, unless you have gotten an extension from the insurance company, that is the end of the claim. If you file suit, the insurance carrier is going to have a good argument for arguing that you didn't exhaust administrative remedies and that you don't have a right to be in court. If an insurance company or an administrator will not grant an extension, submit the appeal on time and just let them know and ask for more time and say that you're going to continue to supplement the appeal. You can continue to send in evidence until they actually make a final decision and get it in the record. If the administrator obtains new evidence on appeal, the good news is, because of some changes in the law, is that they have to give you or your client that opportunity to rebut or respond to that new evidence. In the past, we would submit an appeal, they would hire a doctor who reviewed the evidence and say, this person's not disabled, and then that was it. The record was closed and we didn't have an opportunity to respond. Now we do, especially if that medical review is going to be adverse. At some point, there's, the back and forth needs to end, but it's really important to get rebuttal information if they do get a medical review after you submit the appeal that disagrees with your evidence. Okay, so what is the administrative record? The administrative record, we're not talking, when I say, submitting an appeal, we're not talking about an administrative agency like the EEOC or the DFEH. We're talking about an appeal to a private insurance company, but we use the term administrative record, but it's basically all of the evidence or the documents, information that was submitted, considered, generated in the course of deciding the claim and in deciding the appeal. And so it's important that, because the court's only going to look at the administrative record, that everything that you want to submit, you do prior to the insurance company making a final decision. So judicial review is generally limited to that record up until the time of a final decision, with limited exceptions. If it's a de novo review case, meaning that the court is going to look at the claim anew and not give deference to the plan administrator, they can admit new evidence, but only under really limited circumstances, and that's to enable the full exercise of informed judgment. So if there's something that you're holding back because you're like, this is going to be the smoking gun and I'm going to, lay it on them in litigation, don't do that. because there's a good chance you're not going to get that evidence in. Another way to get new evidence in is that if you could argue that there were some procedural irregularities that happened during the claims process where the record wasn't fully developed as a result, and so getting in the new evidence sort of cures that defect. Okay, so how do you prepare a strong administrative appeal? The first step, the first thing that we always do is get the claim file from the administrator. That is going to have all of the evidence and all of the reasons for the claim denial. The denial letter itself should explain why the claim is being denied, but you get extra tidbits when you request the claim file. You get to see the insurance company's internal notes, the medical reviews, vocational reviews. If they did surveillance, you'll see that. And a lot of times claimants have no idea surveillance is being done, especially if it wasn't damning enough for the insurance company to put in the denial letter. But that, there are a lot of surprises that come up when you get the claim file. An appeal. Unless you are submitting an appeal at 11:59 on the date that it is due, a statement just saying I disagree with the decision and I appeal is typically not enough. Remember, a reviewing court is going to be limited to the record that was developed before there is a final appeal decision. So you definitely need a lot more than just a letter or a statement stating that you disagree with the decision. You want to make sure that if the basis for the denial is that somebody is not disabled by their medical condition, you want to make sure that all the medical records are submitted. So that's why getting the claim file is important, because you can look at the claim file and the client would say, my doctor said they sent in everything. And then you look and there's nothing from that doctor, which happens because sometimes insurance companies are notorious for losing things supposedly that were sent in by doctors' offices. You want to make sure that you don't assume that what you think is there, and if it's missing, go out and get it and submit it with the appeal. Okay, medical records. Medical records are going to be the #1 source of quote unquote objective evidence. Records usually include statements of like your current symptoms, other medical conditions that might affect or lengthen the recovery period, if there are existing abnormalities or deficiencies, results from physical examinations, observations made by the provider, diagnostic tests, lab results, x-rays, MRIs, if they have those that can show that there is, degeneration or there's something that's abnormal, that's going to be really helpful. Treatment plan, if there are medications that a claimant's taking, are there side effects? A lot of times our clients are disabled because the medication that they take to treat their really disabling pain also causes pretty disabling cognitive side effects. That's important. It's important for claimants to report that to their doctors. Other evidence that we like to get as well for these appeals are letters from medical providers. And we like to have them address adverse opinions that were made by the insurance company's medical reviewers. And I also opted, lately what we've been seeing are a lot of problems with medical records. And I actually think it's a good idea to send clients, as we get them, copies of their medical records, because it's happened well more than once where someone looks at the records and say, that's totally incorrect. I didn't report that to the doctor. They mischaracterize that. And then having that corrected in the medical file, because once you're in court, or the medical reviewers will do this, they'll really cherry pick a lot of things that are in the medical record. So if something is wrong, you want to get that cleared up and have an addendum made to the medical record or have it addressed by the medical provider. If there's surveillance, it happens. Sometimes there's surveillance of the wrong person. You want to make sure that's cleared up in the appeals process. Declarations from the claimant, friends, coworkers, anybody who can support disability is important because, like I said earlier, there's no jury trial. And there's really no opportunity, at least here in the Ninth Circuit, for the claimant to get on the stand and testify to the judge. This is not like, a Social Security hearing before an administrative law judge. So any testimony that you want to get into the record that you want the judge to see down the line needs to be in the form of a written statement. You could also do video statements. We've done that as well. And that's the only time that a judge is going to see your client. We also get functional capacity evaluations and independent medical exams where we think that they're important to supplement what is in the medical records and to really kind of show how one's subjective complaints or their medical symptomology impacts or impairs their ability to perform their job. Often we find that vocational analysis is important. What is someone's own occupation? What are the material and substantial duties, and can the claimant perform them? Medical literature, especially for certain conditions that might not be as well understood. And especially when you're citing to judges. Judges aren't doctors, and so I often find that having the medical literature in the claim file already makes it a lot easier when you're briefing the case to the judge, and you don't have to cite to outside sources where then argue the judge should take judicial notice. And then the Social Security file, if they have Social Security approved, can be really helpful. An insurance company is not bound to follow Social Security's determination, but if they're going to reject it, they really have to provide a compelling reason for rejecting that. And so having the full Social Security file can be helpful. Where it might not be helpful is if you have a client who has a combination of physical and mental disabilities, and you're trying to get their claim, their disability, their LTD claim extended on the basis of a physical disability, but the Social Security file is really heavy on the mental disability, then it may not be as helpful. So you can, review it and then decide how you want to proceed. We also find a lot of help in workers' comp files. There's a lot of QMEs and medical exams that are done that can be really helpful in providing objective support of disability. Okay, and I know I'm going over a little bit. We had some questions, but I really want to cover this last topic, which is avoiding inadvertent waivers of ERISA claims. And I am seeing a lot more of this now in my practice, especially as there are all these layoffs happening and all these severance. People are signing severance agreements and they don't realize if they have an open disability claim or consider filing one under their employer's plan, they may be waiving that right to do it. And so you want to review the severance agreement, ideally before it's signed, and see if the ERISA claim is going to be waived. You got to look at, who are the parties? Is one of the parties the employee benefit plan of the company? That's probably you're going to be deemed as waiving the claim. If the release claims explicitly include ERISA claims, that's probably going to be deemed as waiving the disability claim. Certain ERISA rights can't be waived. Vested benefits, particularly pension benefits that are vested, cannot be waived, but disability benefits aren't considered vested benefits. And there have been a lot of unknowing waivers of disability claims. So it's hugely important. The easiest thing to do is propose an explicit carve out for specific employee benefits if there is going to be a claim or an ongoing claim. Often the employers don't really want to mess with somebody's disability benefits, especially if it's an insured plan. The employer is not paying for it, but if there's a dispute down the line and a lawsuit's filed against an insurance company, they're going to request the personnel file of the claimant from the policyholder. And if they see that release agreement, they will try to piggyback on that. And so you want to make sure that that is going to be protected, because it can make it really difficult to pursue this claim in litigation if the insurance company has a good argument that your client waived the claim. And I just provided a couple examples of language that could be included in a severance agreement, which should be enough to protect the claim if there is a dispute down the line and the insurance company gets a hold of the policy, or I'm sorry, of the severance agreement. Another thing to keep in mind too is that a lot of LTD policies will offset severance. Meaning that, they'll reduce the LTD benefit by what the employer pays in severance. So if that's the case, you want to make sure that your client is counseled on exactly what they might be giving up. But it may also be an opportunity if you depending on the nature, the relationship with the employer and and the basis for the severance payment, recharacterizing the payment is not severance. I mean, that's one way to go about it, but it's just good to be mindful because a lot of people don't realize it. And then they realize, well, you know, I didn't make any more money because everything I got in severance ended up being an offset from my long-term disability policy. So definitely keep that in mind. And that is the end. And so I'm happy to answer any more questions. We do have a few minutes left.
Great. Thank you so much, Michelle. We actually don't have any more questions that have come through the Q&A, but we can give people just another quick minute to do that. Again, I'll go ahead and send out this survey evaluation that you will need to complete for CLE credit by email. And if you are interested in joining the panel, please don't hesitate to let me know. Would be happy to provide more information if you're interested. And it looks like we have one comment that just came through. Excellent presentation, so comprehensive.
Thank you.
And I think that should do it for today. Thanks again, Michelle, and thank you everyone for joining.
Thank you.